If your loved one died without a will, you probably got contacted before the probate petition was even filed, asking you if you'll waive bond. If your loved one died with a will, the will itself may state that there's a waiver of bond. And I'm going to discuss with you whether that's wise or not for your particular situation. You'll learn what bond is, when bond comes up in probate litigation, whether you should agree to waive bond or whether you should require bond to be posted. Bond is simply an insurance policy. I know it's an odd word, but it's the word that California has chosen. Bond is simply an insurance policy that insures all the heirs or the beneficiaries against any losses the estate may suffer because the executor or the administrator breaches their fiduciary duty. So there are two ways that bond can come up. The first is where there's no will. If there is no will, then the administrator of the estate must post bond unless all of the heirs waive bond. And a bond waiver is a document that you'll sign that says quite simply, you know that bond would have to be posted and you're agreeable to bond not being posted. The second way this comes up is under a will, because a will may either be silent on the issue of bond or the will itself may say that bond is waived. Where there is no will, you're probably going to be asked to waive bond. And whether you should or you shouldn't is absolutely going to depend on what is happening within your family and the particular probate estate. As a general rule, if you have any hesitancy at all about the person who's going to be in charge or the assets they're going to have to deal with, then don't waive bond. There's no good reason to waive it because it is nothing more, as I've already discussed, than an insurance policy. So there will be some expense to the estate, but that's about as bad as it gets. It's a minor expense. You're now protected. Probate is going to proceed just the way it always does. The bond doesn't change the course of probate. Where there is a will and the will has waived bond, that doesn't end the discussion. You as a beneficiary under that will have the ability to go to court and ask the probate court judge to impose bond. Now, it is a little bit different than the situation where there is no will because it's not automatic where there is a will. If you want bond to be imposed, you're going to have to explain to the court why bond should be imposed and what amount you believe is appropriate. And judges where there is a will have a great deal of latitude. So make your best case for why bond should be imposed if you believe it's needed. Now you understand how bond operates in a probate case. Thanks for watching. Our next video is going to address litigation to get property back into the probate estate. If you found this video helpful, then please hit the subscribe bell, leave us a comment. We'll be glad to respond if you do, and give us a thumbs up.